YouTube, it's Tom back with another one for you. So this one is a continuation of the book Foreclosure Defense Handbook. This is the third edition here in the videos. It's going to be a few of them because this book is long. So alright, so let's get into this. So right now we're in a section we pretty much got to the bottom of how this scam is perpetrated on everybody. So let's go a little more into detail, talk about some codes and statutes to back up what it is that's being said here in this book. All right, because this shit is all law. It's just that nobody nobody has time to read these 10,000 page books. You know what I'm saying? So let's get into it. So this is the scam that the bankers don't want you to know. So the great pretender lender switch. This is how the scam is being perpetrated by your so-called lender. They advertise they offer loans. They work with the mortgage broker and network around the nation and consumers to apply for the loan. Once the loan has been approved, the word approved very loosely because very little due diligence is actually being done by the so-called lender. They are pre-placed into a REMIC. The lender then waits for the paperwork to be signed. Once it is signed, it is immediately transferred into the REMIC. Once a REMIC has enough loans to be packaged, it then gets registered into the SEC database and then gets converted and traded as a stock. All the while, unbeknownst to the consumer, the lender all of a sudden switches their position from lender to servicer of the note. Again, as you recall, under the accounting rule FAS 140, once an asset has been sold, the lender forever loses control of the asset. In other words, they no longer own or control your loan. They merely act as a servicer of your loan, with the proceeds going directly into the REMIC to be distributed to the shareholders. Remember, since the lender is just a servicer, they do not own the note. They do not have the right to enforce the note. They can only act as a servicing agent. Please refer to USC Code Title 12, Banks and Banking, Part 226, Truth in Lending, Regulation Z. This is enclosed in the appendix for your convenience. These are codified laws of banking. It defines who a lender is and what the rights of a servicer are. Specifically, it refers in 226A1 that a servicer is not treated as the owner of the obligation. So scope, disclosure requirements of this section apply. Covered any person except otherwise would be provided in this section. For purposes of the section, A, covered person means any, hang on, let me write this time down. Any covered person means any person as defined in 226 that becomes a owner of an existing mortgage loan by acquiring legal title to the debt obligation, whether through a purchase, assignment, or other transfer, and who acquires more than one mortgage loan in any 12-month period. For purposes of this section, a servicer of the mortgage loan shall not be treated as the owner of the obligation. Meaning right here, so if you want to break it down, for purposes of this section, a servicer of a mortgage loan shall not be. And when it says shall not be, when they talk about it in this, it means will not be. So for the purposes of a servicer, mortgage loan shall not be treated as the owner of the obligation, meaning that they will not be treated as the owner. So if the servicer holds the title or is assigned to the servicer solely for the administrative convenience of the servicer in servicing the obligation. You will also note that the scope does not cover the servicer if the servicer was assigned the note for administrative convenience in servicing the obligation. This means the servicer is not treated and does not have the rights of a lender or owner of the obligation. As I discussed earlier, even if the servicer was to buy the note back after it had been securitized, reattached of the loan note to the deed, trust mortgage is impossible. So this is basically saying that they cannot connect it back to the property at all, even if they go and buy the debt back secondhand. So you cannot make carriage from carriages. Once a loan has been written off, it is discharged. Once a loan has been securitized, reattachment is impossible. Reattachment is impossible for the following reasons. Number one, permanent conversion. The promissory note had been converted into a stock and as a permanent fixture. Its nature is forever changed. It is now forever a stock. It is treated as a stock and governed as a stock under the SEC. So since the deed of the trust secures the promissory note, Once the promissory note is destroyed, the deed of trust secures nothing. Therefore, the trust is invalid. So number two, asset has been written off, and this is the shit that I was telling you in the last video, that these people will go and fucking write off the whole amount of the loan, get the credits from the Treasury Department in the form of tax credits by them not having to pay taxes that would have been due otherwise, and then they're gonna go ahead and turn around and try to charge you the full amount of the fucking note, even though they already got their credits. That's double dipping. That's fraud. That's a bunch of shit. You know what I mean? And this is what the fuck that they do. So number two, asset has been written off. Once an asset is written off, the debt is discharged. And mind you, one time I called a fucking a debt collector company when I was looking into my credit to fix it, and there was a debt collector that was claiming some crazy shit from like a car thing that I had a while back. And I ended up calling him on the phone. I made sure that it was a recorded line, and I dropped the fucking hammer on him. I mean, you could imagine the shit that I fucking told him. But then at the end, I was like, look, and so make sure that you send this over to your legal team. You know what I mean? And I'm gonna start charging you XYZ from now moving forward, and this is fucking your official notice. You know what I'm saying? 2 weeks later, everything was fucking taken off. So that's how that goes. And this shit is a fact. So just pretty much to sum it up, once it's been written off by these people and they get their tax credits from the Treasury Department, they cannot legally charge you that money in the fashion that they do. I mean, the administrative process is crazy, and you guys should definitely study that too. Don't go leaving that behind. Definitely make that part of your studies, because that shit is crucial. Because that's exactly what they're doing. They're just pretty much fucking administrative crooks. You know what I mean? So the servicer acts as a debt collector of an unsecured note. The servicer is deceiving the court, the county, and the borrower when it tries to reattach the note of the deed of trust as if nothing has happened. It's called adhesion. The funny thing about this law, it's legal. And so this is why I kind of was stumbling when I was just talking about the scams that they pull, because technically the fucking administrative process that they pull on you with the scam kind of makes you liable, because you pretty much accept the note as being a fact without challenging it. And if you take it, accept the offer, essentially is what it is, then technically you're bound by that. You know what I mean? But it is done in a real fucking scandalous way that I don't really think is legal, to be honest with you. But it could be twisted into made to believe to be legal, but it definitely isn't. It's fucking scummy. So the funny thing about the law is it's legal until or unless the other party objects. And so that shit is crazy, right? So since the scam is so devious, it is beyond the comprehension of most people. And that's the thing too. I think most people don't want to think that these motherfuckers are like that, so it's hard for them to wrap their mind around the fact that they're literally pulling a fucking scam on them. But they are. You know what I'm saying? And this is the thing. So they paint these pictures of what the devil looks, of what a crook looks like, and all that, right? And then they go and they fucking throw on a suit and rob you fucking blind, because you're looking for a dude with a hoodie that they told you was a crook. Meanwhile, they're fucking robbing you and fucking stole your house because they had a suit on. So just be careful with, you know, things like that. Including that of lawyers and judges. So it's beyond the comprehension of most people, including that of lawyers and judges. And I think that that's because people are, for the most part, good people, and they don't want to believe that somebody would do that. But that's it. But this is exactly what the fuck these scumbags are doing, and it's all over the world. And it's not to any one type of person. It's to everybody. They're fucking everybody. So it's beyond the comprehension of most people, including that of lawyers and judges. It takes someone who has studied accounting, securities, and law to unravel this deception. And that is true. I mean, luckily for me, you know, I have the capacity to understand things on a really multifaceted level and from a bird's eye view, and that's really, if you can't do that, it's fucking impossible for you to even wrap your mind around this shit, because it really is a big fucking multifaceted fuckery fest. It's crazy. So most people in the legal profession only take the arguments on face value. Broken chain of assignment. So under the Uniform Commercial Code, the promissory note is one-of-a-kind instrument. All assignments, much like endorsements on the back of a check, have to be done as a permanent fixture onto the original promissory note. The original promissory note has the only legally binding chain of title. Without a proper chain of title, the instrument is faulty. So rarely can a lender produce the note because by law the original note has been destroyed. And that's the thing, because it got converted into a security, they can never pull out that fucking original note because it already got converted. What they'll try to do is bring up some type of state statute or some shit like that and try to reprint one or draw one up as if they have authority to do that shit. Really, that's fucking identity theft, if you want to be real. So the note and the stock cannot exist all at the same time. Oftentimes, the lender would come into the court with a photocopy of the original copy made years ago, and that's what I'm trying to tell you. They can't do that because it doesn't fucking exist. They already converted it. So another popular method of deceit lenders prefer to use is the state civil code. In a non-judicial state, there is no law requiring a lender to produce the note or any other proof of claim. They don't have it and cannot produce it. It doesn't matter what the fuck code of statute that these people pull up, because ultimately we're dealing with a commercial matter which the Uniform Commercial governs entirely, and it doesn't fucking matter what code, state, or statute says. So, and they don't have it and they cannot produce it. Oftentimes the lender would do blank assignments of the original promissory note into the remit. Then when they need the note to perform the foreclosure, they will magically produce a blank assignment. Again, this is not legal and is bringing fraudulent documents before the court in the county of record. And that's what I'm trying to tell you. This shit is all fraud. And if you don't catch it and call them out on it, and then you fucking accept their offer and move forward as if what they're saying is a valid argument, then you fucking give them the jurisdiction and the right to do what they're doing. To be honest with you. Because that's just the way that the system's set up, but it is fucking grimy, and I'm sure they're gonna pay for that on some level anyway, to be honest with you. So let's be very clear. Once a loan has been securitized, the note is no more. Anything the lender brings into court as evidence is prima facie evidence of fraud. The attorney for the lender is either an accessory to fraud through ignorance or willful intent. Either way, as an informed borrower, it is your job to bring this deception to light so these lawyers can be sanctioned. So your lender would close your loan, sell it to the remit, and get paid. Once your loan goes into default, the loan is written off. The loan is then bought by the same lender in the open secondary market as a dead unsecured note to be able to pull this stunt off. Every lender involved in this scheme is required to act in collusion. Once the servicer buys the dead note, they then claim to be the true holder in due course of a written off asset. Then they present to the world as if they are the ones who claim. They rely on the homeowner borrower to be ignorant of this deception and clean up, allowing them to take possession of a house for pennies on the dollar. This is the extent of the fraud to the American public every single day. As a homeowner defending your rights, it is imperative that you understand the nature of this fraud so you can use these arguments to defend your home. As a legal professional, it is imperative that you understand that these arguments so you can raise the proper objections and interrogatories when representing your clients in a foreclosure defense. Now, you guys see exactly what it is, and it's pretty clear, right? You know, so we got a few more videos. We're going to get into some more codes and statutes in the next video. You know what it is. It's a game of chess. Stop playing checkers with these clowns. That's what I got for you for now. Until we meet again.